The Findling Law Firm. The Findling Law.
And we'll just keep it down so since we have actually have a reporter here. We'll let her just do all the questions.
No, you're going to have to let me go with this, okay? So let me start by telling you that this is not going to be a Q&A, and that's going to make sense when you hear the subject matter to be addressed. It will make 100% sense. And we are going to later on hand out a very relevant document that I think will resolve any questions that you have. So let me address the reason why we're here today. As most of you know, by statute, the governor of Georgia had no choice, but because of the federal indictment of Sheriff Hill, had to select a three-party commission to advise him on whether or not to suspend the sheriff. In fairness to the governor, he had no choice. It's mandated by statute. The statute tells him that, one, it should be the Attorney General for the state of Georgia, the top lawmaker for the state of Georgia, and two duly elected sheriffs from one of our 159 counties, and he did that. We know that that commission did recommend suspension. Specifically, that same statute says by executive order, the judge notifies the public, which he did, that there will be a suspension pending the indictment of Sheriff Hill. That same statute very, very specifically states that although the executive order is public, the findings of the commission are completely confidential for the eyes of the governor of Georgia only. We now learned, as most of you know, that the commission's report, was leaked. It was disseminated to the public. It was a news story, and in fact, from what we know, even one of the three members even gave an interview or at least answered questions regarding it. And so we, because of this clear violation of the law, the statute is clear as day, on Friday, electronically and in overnight delivery service, have requested the governor of Georgia, Brian Kemp, to conduct an independent investigation as to how this leak took place. Because remember very clearly that there's a reason for the private nature and why it is kept confidential. And that is, it honors our legal system. It was a one-sided study without the sheriff or his defense counsel having the ability to participate in any way, no appearance, no anything like that. And what it does is it poisons a potential jury pool. It has now presented a problem to our defense of Sheriff Hill. And our concern about that is that this is yet another example of the unfair treatment of Sheriff Hill. It is another example of him being singled out. The very essence of why this is taking place is because a federal color of law investigation and indictment that involves no physical injuries whatsoever, merely 4 incidents referenced out of hundreds. We have scoured as his counsel the nation. We have talked to our colleagues throughout the United States. We have heard, both just spontaneously and upon request, of our colleagues around the country, and nobody knows of a case like this. It is truly unprecedented. At best, or you could say worse, matters like this are dealt with civilly through a consent decree. And so Sheriff Hill has been singled out, in our estimation, prejudiciously. And now, the irony that the governor of Georgia, as required, has the state's top lawmaker and 2 sheriffs that are presumably understand the law and understand the confidential nature of them sharing their findings privately, have disseminated this document. The irony is that Sheriff Hill, beloved by his community for honoring and enforcing the law, has been judged by, one, whole or in part, 3 people that have dishonored the law, that have not followed the law. The irony to us is just too much to understand. And so what we have done, and be mindful of the fact that what is so disturbing about this is that he is so beloved by his community for fighting crime and for honoring the law, that this recommendation has been made in whole or in part by somebody or more than one person that is not following the law. The irony as his counsel does not escape us. So what we have done is we have asked the governor in a document that we will share with you to appoint an independent person or persons to investigate what happened, because the far-reaching impact is too much. The far-reaching impact that a jury pool has now been poisoned is too much for us as his counsel to even comprehend. It is, of course, up to the governor to appoint whomever he thinks is best. The only thing we could tell you is by looking at the statute, there appears to be some guidance, because the statute provides that if the case is brought by the Attorney General of Georgia, which it was not, but if it is, then the Attorney General should be substituted by a retired Court of Appeals or Supreme Court Justice of Georgia. While it's not exactly on point, we think intellectually it would make sense for the governor to contemplate, through his own private counsel, appointing a retired Supreme Court Justice or Court of Appeals judge from the state of Georgia to immediately commence an investigation in this blatant violation of the law. At this time, my co-counsel, Ms. Goldberg, is going to hand to you the letter, a copy of the letter that went out on Friday electronically, and again, in overnight delivery service to the governor, Brian Kemp, the governor of the state of Georgia.
So you have nothing more to say.
One quick question, if you can hear it and then decide if you want to answer. What can you say about his character, despite the criticism and allegations? We hear a different side of him in his community where there's a huge level of loyalty that they have and they want to wait for this to play out. Tell us more about his character.
Well, I will respond to that by just saying this. He is unquestionably and beyond comparison of any law enforcement officer we know of by looking around the United States, beloved by his community. And again, I'm going to tell you the irony that the law, in order to taint and prejudice the fairness of the case against him, lawmakers, either individually, whole or in part, have violated the law, does not escape us.
Is this big grounds of change of venue?
You still